Just the last name.
DAS RU 528. I'm sure I'm the same.
Castruccia.
Yes.
Got it. Good morning, ma'am. Ma'am, you're charged with possession of a gambling device, equipment, or paraphernalia. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay.
I have on February 23rd, 2026, the officer conducted an investigation at Smoky Smoke and Vape Game Room in Harris County, Texas. The execution of a search warrant was conducted, evidence of 777 gambling machine and 8 liner, and a winning of $136.50 with a $2 wager, which is more than 10 times their original wager. The defendant has a prior criminal
Yeah,
history.
I see that. No, she has a prior one that was just same thing dismissed, not like 4 months ago.
Right, that's not evidence of probable cause. What we're missing here, what the ADA didn't read is the officers say we tried to get in, we couldn't get in. We somehow go get a search warrant. They go in and during the execution of the search warrant, they sit down and play the machines. There is zero evidence of cash payout.
I guess I missed that. Guys, what say you?
Yes, Your Honor, I'm looking for the different.
Yeah, I don't care about, for probable cause purposes, I don't care about the last one. But
Yeah, they say specifically.
did they get paid out on this?
Your Honor, there was a winning of $136.50.
Did they get paid out on it?
Your Honor, there's nothing but a payout in the DIMS.
So basically she goes, or whoever goes, I guess the officer goes, plays on the machine, wins $10,000 and then just ups and leaves?
He plays, or he or she plays during the execution of the search warrant. They never get in and recover. So I don't even know.
How do they even get the search warrant?
That's my question, but they say they go in and they.
No. I mean, this
She in custody.
shoot first, ask questions later, you know what I mean? No problem cause. I'm with you. Okay, thanks. Herman, right?
Yes,
Hey, good morning.
I'm here for one of my clients, which is Ms. Martinez.
Okay, just last names for both.
Martinez.
Okay, do you mind bringing them up?
Martinez, can you come up this way, please? And
Do you
then
have 2 cases?
I have one with subbing in from Mike, or helping Mike out for the Ravens. She had to go to Fort Bend.
Are they both DWI?
I don't know what Mike said.
So what's the last name on Mike's?
I will defer to.
It's a reckless driving.
Okay, let's do them both,
Okay.
since you're here. Both.
Rocky?
Oh, the way.
And was Miss Martinez?
I'm not sure. Cool.
Coming up, sir. All right, good morning. Both of you are charged with criminal cases. Both of you are facing, well, Ms. Martinez, you are facing up to 6 months in jail and or a $2,000 fine. Mr. Tachi, you are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause on both of your cases. Each of you have the right to remain silent. Anything you say can or will be used against you. Okay,
I'll start with Ms. Martinez, Your Honor.
dealer's choice.
On March 1st, 2026, officer in Harris County, Texas, observed a motor vehicle failing to maintain a single lane and failed to use a turn signal. The vehicle continued to drive over a yellow line on the roadway as well. A traffic stop was conducted. The defendant, the driver, had red glossy eyes, a strong odor of alcoholic beverage, slurred speech, and looked disoriented. Defendant advised that she had 3 drinks. Standard field sobriety tests were conducted, 6 out of 6 HGN, 6 out of 8 walk and turn, and 3 out of 4 one-night stand. DIC was read and a breath sample was provided. results were 0.129 and 0.121.
She said she was driving on the shoulder?
So she was failing to maintain a single lane, failed to use her turn signal, and was driving over the yellow line of the
She
road.
didn't have to put her turn signal on, she didn't make a turn, Your Honor, and, you know, and she wasn't unsafe to herself or anyone else.
Change lanes.
She did not change lanes.
She was failing to maintain a single lane, and
She didn't change.
as she was failing to maintain a single lane, she was not using a indicator when she was going into the next lane.
Well, she didn't, sorry, Fargo, she didn't, I didn't hear the Div say she went into the other lane, that all he's saying is that she
But
was
she
on.
did that coupled with she's driving on,
She was driving over the yellow line, Your Honor. I'm looking at what it states in the DIM specifically.
read it again, if you don't mind, please.
Yes, Your Honor. So this is straight from the DIMS, Your Honor. Officer observed the vehicle failing to maintain a single lane after crossing back and forth over the white striped line back into the original lane. Officer observed the vehicle failed to utilize the vehicle's turn signal as the vehicle was traveling in the middle of the white striped lines. Officer observed the vehicle merge towards another roadway and observed the vehicle drive over the yellow line of the roadway.
So she's merging into another lane?
So it states specifically merge westbound towards the sorry, Your Honor, I'm just looking at the DIMS right now.
Sure, take your time. And weaving within the lane is not a problem, right? If you're going to move to another lane, then you have to indicate your intent. But weaving within the lane, and if you're crossing over a yellow line, I mean, are we to assume that she's changing? You said she's going west?
So she's traveling south, Your Honor.
Does it say that?
She's traveling in the, so officer observed the vehicle continue to travel southbound and then merge westbound towards the 11800 South San Houston Parkway East.
But he didn't say when she merged there that she put on or didn't put on a turn signal. His reference is to when she was within the lane touching the other lane. He doesn't indicate when she merged westbound that she failed to signal.
How do you respond to that?
Your Honor, the officer observed the vehicle crossing back and forth over the white stripe lines. She was failing to use her turn signal as she was going between those two lanes.
That's exactly my point, that the merging.
So I think, so white line is, you know, there's two lanes going south. Right? She's
Well, we
going
don't know if it's
between
the white-
one and the other one.
It's the solid white line or the ones that break apart. I don't think that's not.
Regardless, whether it's or, you're still going into another lane.
No, but my indication was when she then merged westbound, there was no indication in her DINS report when she turned westbound, whether there was a light.
Well, now you're moving on to something else.
Well,
Herman.
in the lane, you could, like you said earlier.
But this is not in the lane. It's a different lane, right?
She was back and forth between, over the white stripe lines, back into the original lane, meaning she was weaving in between two lanes.
That's a leap of faith that's what it's saying. He's just saying that she's going to the line.
Between lanes means two different lanes. Otherwise, you would say weaving within the lane.
I didn't hear that she went into another, but I was checking what the
Yeah.
report here.
I think that there's enough for probable cause purposes, it's enough to go forward, Ms. Martinez. I am going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Any prior to the eyes in the Chevy license?
No priors, Your Honor, her license is eligible.
Okay, Now it's Mr.
And just,
Tucci.
well, okay, just for her benefit, that she doesn't have to appear until.
Yeah, I'm gonna get
You
that
did
too.
but-
On February 26, 2026, in Harris County, Texas, officer was dispatched to a major accident. Officer observed the two vehicles to be heavily damaged. Defendant informed officer that he was a driver of one of the vehicles and that he had been involved in the collision. Defendant stated he had been testing the vehicle's acceleration to determine how fast it could travel from 0 to 60 miles per hour. Defendant acknowledged that he caused the accident and that the speed reached approximately 76 miles just before impact.
I didn't hear anything that's reckless there, other than speed.
Your Honor, he was testing how fast his car could go from 0 to 60 miles per hour, traveling 76 just before impact with another vehicle.
How,
Failing to
how,
control speed, that's also class C.
how in a 35, in a school zone, 65 on a freeway, where is he? You know,
Taking with the pins, Your Honor.
it's gonna be a long day, man. With the reports of the way they're written. My God.
It occurred on Katy Freeway, Your Honor. This is
So 65 on the Katy freeway is reasonable.
He was driving 76 miles per hour.
Oh, okay.
He was testing how fast his car could accelerate from 0 to 60 miles per hour on a freeway with other vehicles around. He was traveling 76.
So
miles.
tell me, that's still conclusory. How does it become reckless? Just, I understand that there's an accident, but you know, you saying you're testing the wheels, that's conclusory. How, detail and tell me how it's reckless, other than I know that there's an accident. How? Were there other cars there?
Yes, Your Honor. Defendant stated himself that his speed this is straight from the DIMS, Your Honor, his speed reached approximately 76 miles per hour just before impact.
Guess everyone, most of the people around the Katy Freeway getting reckless driving. I mean, anyone that drives in the Katy Freeway knows how fast people drive. I mean, that's all he's doing is driving fast. Admittedly.
You know, I took my mom on a test drive, right? I was 16 at the time and the Mustang 5.0s were had just come out and had no idea. And I slammed my foot on the gas and the car went, phew, and then I immediately took it off, right? Nothing happened. Is that reckless?
Your Honor, he himself.
On your mom or you? So,
You know,
He himself admits that he was testing how fast his car can go from 0 to 60 on a freeway with other vehicles around. I would argue that.
what kind of car was it?
It was a Dodge Ram, Your Honor.
I understand it's an accident. Does it rise to the level of criminal culpability? I don't think so. It was an accident, right? You put your foot on the gas. You have to specifically intend to be reckless. Like I'm driving like a maniac. I'm weaving in and out of lanes. I'm cutting cars off. I'm going at 110 miles. Reckless, right? Accident is something else. It's a specific intent crime. You have to specifically intend to be reckless, not I put my foot on it and it was an accident and I didn't realize, you know? No. All right, I'm going to find no probable cause on this too. Touchy. Please be careful. We have enough accidents on the street. And if you're going to drive, have car insurance. You understand? If I find you back here, all right, please.
Ms. Martinez, right?
Okay.
All right, Judge, council's approaching for page 18. Fleischer, May.
It's Michael Wearsoma.
Just last name, please.
Wearsoma.
Okay.
Good morning, Judge.
Good morning. How are you? Happy Friday?
How are you, sir?
Finally Friday. All right, good morning, sir. You're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. please.
On February 28, 2026, in Harris County, Texas, the officer observed a vehicle going 96 miles per hour in the 60-mile-per-hour zone. Officer observed the vehicle to make multiple unsafe lane changes without signaling, causing other vehicles to brake abruptly.
That's reckless driving.
For the video, so match.
The vehicle nearly struck another vehicle and was following other vehicles was following the vehicle in front of them too closely. Traffic stop was conducted and the driver was identified as the gunman.
Sir.
Briefly, and I've shown, I've already gone through the videos on this and showed the state. The videos do not match that. My client did not almost cause a accident. He did fail to use his signal once to move over into a lane when there was no vehicles over there, and he was speeding.
But I
there's
can't-
not match.
But I can't get into that.
I
mean, you
those
know,
are fact issue questions. And the
Sure.
state and I have already worked them out. I just wanted the court to know and be aware. Already did my homework on this, already showed the state.
Great.
We're ready to go.
Mr. Wilson, if I find that you drive like this again, I'm going to revoke your bond. I will put you in jail and I'm going to take your ability to drive away from you. Do you understand? No more reckless driving, maniacal, speeding like this, cutting people. If I find that you do, I only have one place for you. Do you understand me?
Yes, sir.
Do you mind filing conditions such, please?
Yes, Your Honor.
I'm gonna have you sign a reset. We'll have you take a seat in the jury box while we get bond conditions. Once you sign them, at that point, you'll be free to go. No more. You understand? I have no problems throwing your ass into jail and making your bond high. You understand?
Yes, sir.
All right.
Thank you, miss. Appreciate it.
Thanks. All right, Mr.
All right, Judge, council's objection for page 13,
Okay,
Quintano.
good morning. Good morning, Mr. Quintana. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 1st, 2026, in Harris County, Texas, officer was dispatched to a suspicious person call. Witness stated she saw two individuals wearing all black and ski masks pulling on door handles of vehicles in the parking lot of an apartment complex. Officer located the suspects matching the description given. Defendant fled on foot in the direction away from the apartment complex and proceeded to jump over a fence. Defendant continued evading for half a mile. Officer gave verbal command to defendant to stop. Defendant was then detained.
Sir, you said there's a co-defendant?
There is no co-defendant, but there was two individuals.
So they didn't get the other one.
I don't believe they
Okay,
did.
what time of day or night was this?
The dim's not specified the time of day. But I can take we don't have an office report in yet either. But there's no specific time of day stated in Your Honor.
Mr. Quintano, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you do, I'm going to lock you up. I'm telling you now that I'm going to test you within a week. If I find that you're using, and I don't care what it is, you will go to jail. This is not a revolving door, and I'm not going to give you PR bond after PR bond. If you go to jail, that's where you'll stay with a high bond. You understand? What are you doing with yourself these days? You are 17. You've not picked up a criminal case. What are you doing with yourself? Did you graduate from high school?
I'm a senior in high school.
I'm now giving you a curfew. I don't want you out past 9 o'clock. If I find that you do, likewise, into jail you go. So no co-defendant.
We do not have a connected co-defendant, Your Honor.
Okay, and also as a condition of your bond, you're not to go back to this apartment complex and you're not to be in possession of any weapons. I'm also ordering you to either have a full-time job or be in school full-time. But while you have this case open, just You're not gonna sit at home and play Xbox all day. You understand? It's time for you to become productive, either graduate from high school or do something else productive. But if you have too much time on your hands, what happens? Become self-destructive. You understand? Okay, I'll have you sign your conditions, then we'll give you a reset. Okay, thanks.
Oh, yeah.
All right, Judge, next is top of page 1, Adame.
Good morning, Mr. Adame. So you were charged of failure to stop and give information. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you soon.
On February 28, 2026, the officer responded to an accident call. Multiple calls for service were made while complainant witness followed the defendant. Defendant's motor vehicle. The complainant witness advised upon arrival that she was traveling on Lauder Road. When the motor vehicle attempted to merge, the driver began tailgating her. Complainant witness advised defendant maneuvered his motor vehicle into the left turn only lane. And when the light changed, he merged in front of her and began brake checking her. Complainant witness advised defendant then used side mirror to strike/cause damage to the right front quarter panel of her motor vehicle. The complainant witness then pulled into the gas station and defendant followed her into the lot. And they had a verbal argument which continued. The defendant refused to exchange information. The complainant witness followed the defendant until he stopped at a different location, a different gas station.
Then is that where they caught him? I mean, it doesn't really matter. He just failed to stop. Does he have a license to drive? Mr. Adame, I'm going to find that there's probable cause to go forward with your case. You are not allowed to put your hands down. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You are not to have any contact with the complaining witness in this case and not to be in possession of any weapons. If I find that you have any more road rage incidents, into jail you go, and I'm going to make your bond high. Do you understand me?
Yes.
I'm going to protect my community at all costs. I don't care who you are. I don't care what color you are.
Yes, he does.
We are going to reset your case to give you time to hire a lawyer. I'm going to have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box. I'll get your bond conditions. When you sign them, at that point, you'll be free to go. Come on.
All
Do you mind
right,
filing no driving without a license, insurance, no contact with the complaining witness, no
Martina?
weapons, please?
bottom of page 8, Martinez. M is the first name.
Good morning.
Hi.
Bottom of 8.
Last name is Martinez, first name is Mark.
Stop. I just want last name.
Understood.
Good morning, Mr. Martinez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
On February 27, 2026, the officer in Harris County, Texas, observed a motor vehicle with no front license plates change lanes without signaling. Excuse me. The officer conducted the defendant driver. It says RGESS OAB.
Yeah, so strong odor of alcohol in the
Okay,
breath,
I'm sorry.
red bloodshot eyes. That's okay.
And then the defendant advised he had 4 alcohol beverages. The FSTs are 6 out of 6, 3 out of 8, and 1 out of 4 on one mixed in. The breath showed 0.86.
Okay.
A 0.81.
You said the stop was for what?
I'm sorry.
What, the stop was for failing to signal lane change? Yeah.
And no front license plate. No front license.
Got it. Okay. Any prior DWIs? And does he have license?
No prior to government license bill.
Got it. Mr. Martinez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You're going to be tested. If I find that you're using, I will put you in jail. No more PR bonds. Do you understand, sir? You're not allowed to drive unless you have a valid license. You must also maintain liability insurance in your name. If you don't have car insurance, then likewise, no driving. That is also a condition. Do you understand?
Yes.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you, then I'm going to revoke your bond. Do not pick up any new cases. Do you understand? We'll have you sign a reset. You'll get with Roxanne for your bond conditions, and then you're free to go.
Thank you.
Thank you. Okay.
His mom's living alone, there's one part-time at Cheddar's. He works 2 to 3 days per week. They close at 10, and he goes from 5 to 10, but sometimes he has
It's
to.
bring it through, and then we'll tweak it to what it works. Okay? Yes, ma'am. Thanks.
All right, Judge, next is page 3, top of 3, split image, come on up.
Good morning, Ms. Clifton.
Good morning.
Ma'am, you're charged with terroristic threat. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On February 28th, 2026, officer in Harris County, Texas responded to a disturbance call at a pool hall. Complainant, a worker, advised her former coworker, defendant, had an argument regarding a former romantic dispute where defendant stated, quote, "I will shoot you in your fucking eye." Complainant expressed belief that defendant would carry out the threat, and defendant had previously mentioned owning a firearm, and complainant was in fear for her life.
She said this to him.
Yes, Your Honor, he stated this to the complainant.
Okay. Ms. Clifton, I'm going to find if there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to be in possession of any weapons and not to have any contact with this person. Do you understand? If you do, I will revoke your bond, put you in jail. No more PR bonds for you. Tell me, do you have the ability to hire a lawyer? Okay. Deputy Williams will give you an application. I need to know everything about you, whether you have a job, how much money you have coming in, any other sources of income, kind of car, money in the bank, and then I'll take a look to see whether you. We will have bond conditions created for you to sign. Do not leave until you sign them, okay? Okay, please.
And the bottom of page
No
3,
contact, no
what it
weapons,
says, come on up.
and no going back.
Okay.
Yeah, it was Slick Willie, you know what? It doesn't matter. Good morning, Mr. Fuentes. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 1st, 2026, officer in Harris County, Texas, observed a vehicle going 79 in a 40-mile-per-hour zone and failing to maintain a single lane. A traffic stop was conducted. An officer observed the defendant, the driver, to have red bloodshot eyes, droopy eyelids, slurred speech, the strong odor of marijuana, and the strong odor of alcoholic beverage on his breath. Defendant advised he had just left a bar and consumed beer. A probable cause search found cigarillo with marijuana. Standard field sobriety tests were conducted, 6 out of 6 HPN, 7 out of 8 walking turn, and 3 out of 4 one-leg stand. PIC was read and defendant refused to provide a sample. A blood search warrant was executed, and blood was drawn, Your Honor.
Any prior DUIs?
No prior DWIs, Your Honor.
License?
Eligible.
Okay. Mr. Fuentes, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, and that includes marijuana, I will put you in jail. Do you understand? This is not a revolving door. So you go in there. Tell me, do you have the ability to hire a lawyer? We will give you time. I'll have you go to Victoria Center Reset. You'll get with Roxana for your bond conditions, and then we'll see you in a month.
Thank you
Go
so
on.
much.
All right, Judge, next is page 11, Noel.
Good morning, Mr. Norrell.
Morning, sir.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
March 1st, 2026, officer in Harris County, Texas, observed a vehicle traveling through a construction zone with an shoulder, and the vehicle going 89 miles per hour in a 60-mile-per-hour zone, and also closely following another vehicle. A traffic stop was conducted, and the defendant, the driver, was advised he was not paying attention to how fast, or defendant advised he was not paying attention to how fast he was going.
What?
The defendant was traveling through a construction zone that had no shoulder, going 89 miles per hour.
89 in a 20 construction?
Yes, Your Honor.
Does Mr. Norrell have a license to drive?
Running his license right now, Your Honor. Your Honor, his license is eligible.
Take a seat for me in the jury box, so. Let's move on, please.
Top of page 14, Rob.
And Mr. Stahl, you're charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 21st, 2025, officers were dispatched a disturbance located at 3271 Shaver Street in Harris County, Texas. Officers discovered defendant passed out on a portion of apartment 4101. Defendant identified himself and stated his date of birth. Or defendant provided a name and date of birth. Or the date of birth he provided was March 36th, 1987. When told there are not 36 days in March, defendant stated his birthday was on March 26th, 1987. Officer observed several beer cans on the porch and the strong odor of alcoholic beverage from defendant. The resident of the apartment stated the defendant is the ex-boyfriend of a witness's caretaker. Witness told defendant to leave before he called the police, and defendant refused to do so. Officers determined defendant's real name and date of birth, which were different than the name and date of birth he provided. The officers asked defendant if his name was Ryan or the name he provided, to which officer responded, quote, to which defendant responded, figure it out. So he provided a false name and date of birth, Your Honor.
They kicked him out? Is that what you're saying?
Yes, Your
Also?
Honor. Witnesses had told defendant to leave before they called the police, and
Okay.
defendant refused to do so.
Mr. Stowe, I'm going to find that there's probable cause to go forward with your case. I'm going to appoint you a lawyer. Your case is 300 days old, and we need to figure out where we're going to go pretty quick. We set cases for trial at 180 days. So I'm going to appoint you a lawyer today. We're going to have you talk to someone, and we're going to figure out here momentarily. Okay? Don't pick up any new cases. I'm not asking much from you. I'm not going to put any conditions. Just don't pick up any new cases. Stop. There's nothing you can say at this point. Just don't pick up Any new cases? Do you understand? I'm not asking you to split the atom here. All right? I'm gonna have you sign a reset, then we'll have you take your seat in the jury box, please. And then, if you don't mind.
Yes, Judge. Bottom of 14, Sullivan.
Good morning, Mr. Sullivan. Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On December 28th, 2025, in Harris County, Texas, the officer was dispatched to a theft at Walgreens. The complainant witness informed the officers that defendant and co-defendant concealed merchandise from the location and left without paying, passing all points of sale. The officers were given a description of defendants and were able to locate them. Officer got consent to search the bags in their possession and found multiple items that potentially belonged to Walgreens. The officer observed SD and positively identified the defendant and co-defendant as two individuals who concealed merchandise and passed all points of sale without passing. Total of stolen merchandise was $434.87.
So there is a co-defendant.
Yes.
Do you have the cause number by chance?
The landed in court 3 and it was disposed in January.
Is it lower or
Was disposed, so we
it
can't.
doesn't matter?
Yeah.
Okay. Mr. Sullivan, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to go to any Walgreens. If I find that you do, I'm going to revoke your bond. I'm going to put you in jail. I don't know who you have in this life, but if you don't have anyone to pony up 5,000 to 10,000, if I have to revoke your bond, you're going to be stuck like Chuck in there, and it'll be for quite a while. You understand me? Don't pick up a new case. Do you have the ability to hire a lawyer? I have an application on file already. I'm going to have you sign a reset. We'll have you take your seat in the jury box while I find you a lawyer. Do not leave until you sign the bond conditions, all right? Come on. Just no going back to Walgreens, please.
All right, Judge, top of 15, Thomas, come on up.
Right. Good morning, Mr. Thomas.
Good morning.
Sir, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 1st, 2026, in Harris County, Texas, the officer responded to a call to assist officers and spoke with security staff who advised a discharge of firearm was reported. Witness had seen defendant in possession of a handgun. The officers observed defendant from an adjacent parking lot enter into a vehicle. The search was conducted and both occupants were detained, and the weapon seen by the witness was recovered. On defendant, the officer located an unspent bullet in the defendant's front pocket.
How do you know he discharged the weapon?
Looking at the dims.
I get the umbrella's wet, that you're walking in with wet shoes.
Mhm.
It's raining outside, but nevertheless,
Just says
Does anyone
officers
see him
spoke with
shoot?
Security staff. Who advised that no injuries were reported, only a discharge from a weapon was being reported. It does not mention that someone saw it.
okay. Mr. Thomas, I'm going to find there's no probable cause to go forward with your case. Home slice, what goes up must come down. And if you fire a weapon up and it comes down and it kills someone, who gets the charge? There are proper places where you can go to fire a gun. You can even go shoot an Uzi, not in the metropolitan limits. You understand?
Yes, sir.
Please.
Drew. Top of 16.
Good morning, Mr. Drew. Sir, you're charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 27, 2026, in Harris County, Texas, the officer was dispatched to a family disturbance. Complainant witness stated that while waiting outside his vehicle during a child custody exchange with his children's mother, the defendant approached the vehicle and confronted him, screaming at him and punched him twice with a closed fist in the face, causing him pain. Complainant witness stated after he was punched in the face twice, he was punched several times in the chest area. The complainant witness fell to the ground while moving backwards while being chased by the defendant. The officer observed complainant witness to have an inflated bruise on the left side of his face and a red bruise on his knees caused after falling down while being chased.
Got it. Sir, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person whatsoever and not to be in possession of any weapons, not to go where they live, where they work, where they breathe. You do, I will revoke your bond and put you in jail. I will not give you any more PR bonds. Do you understand me?
So he is.
Stop. I don't care. There's nothing at this time that you can say that will change anything. I'm trying to prevent any further bloodshed from happening.
I understand.
Stop. Just don't. You have the right to remain silent. Exercise that right. Everything you say now, they're going to sit there and they're going to type it, try to prove your guilt. Just really.
No.
You need a lawyer. Talk to the lawyer, and the lawyer will properly advise you on what you can and can't say. But just resist all urges. It's not going to help you.
It's not for me.
Don't.
It's for the kids.
Okay, there's a proper way to handle
Okay.
things. If you, I get it, you may have kids. Every father should be entitled to see their kids, but you can't take stuff and you can't take things into your own hands anymore. You've got a criminal case. If you want access to your kids and the other person's not giving you access, go to a family lawyer and then you can get visitation. And if they start playing with you at that point, but don't, the only thing I'm telling you now is don't have contact with the complaining witness. I'm not saying anything about the kids, just this person. You understand? Okay. Do you mind filing no contact, no weapons, no going to where they live or work? And then can you also let the complaining witness know of these conditions so that in the event that there is an issue to let you guys know, and then we can take appropriate action, please?
Can I add one thing?
No, hold on. Let me ask you a question. Do you have the ability to hire a lawyer?
Yes.
We're going to give you time. Before you say anything else, contact a lawyer and they can help you. Don't stop. Just go.
I'm leaving the country.
Okay, so go
That's okay.
contact the
Stop.
lawyer
Okay.
first, and then we can work. When you have a lawyer, I waive appearances so that you don't have to come to court and the lawyer can handle it for you. But you need to get on it quick. Okay,
Thank you.
please.
All right, Judge, bottom of 18, Wilson, come on up.
Mr. Wilson, you were charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On February 28, 2026, in Harris County, Texas, the officer was dispatched in reference to an assault. Complaining witness stated he had been involved in a vehicle crash the previous night where he struck a mailbox. Complaining witness returned to the location to provide his insurance. Defendant's mother approached him in an upset manner and stated the debris from the mailbox caused damage to her car. While speaking to her, defendant pushed him to the ground, causing him to strike his head on the concrete. Defendant struck him with closed fists on both sides of his face. Defendant wrapped his arm around complaining witness's neck, causing him to feel pain and discomfort. Defendant stated he was defending his mother from complaining witness and that he tackled complaining witness after he refused to maintain distance from his mother. The officer observed security footage of the incident.
Well, so he came back to like Mr. Wilson, I'm gonna find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to have any contact with this complaining witness and not to be in possession of any weapons. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. You understand? If you have the ability to hire a lawyer, we will give you time. I'm gonna have you go to Victoria, sign a receipt. We'll have you take your seat in the jury box. So we get your bond conditions. Once you sign them, at that point, you'll be free to go.
Judge, we're waiting on the interpreters. That's it for now.
Okay.
We'll sign in just a minute. 1 second. Sure. Oh.
Hey, Martin, how are you?
Yes, Chief, is there any or library? About government assumptions, is that right? It was off that.
Ariel did not. And then who was the other one? you said?
Margaret, the no.
No.
They emailed me after 2, and I was like, I don't think they focused on.
No, no.
I'm not even.
I granted. There's a couple that we've are you with us today? We've granted a couple already, so you should have a couple.
I've got somebody who's in custody in the back.
You want to talk?
Yes.
Yeah, who you got?
So I have Mr. Cruz Burnett. He's the DWI application from way back when.
Probation records been right for his initial office visit and I'm signed after that.
Interesting work. He was placed on a 2-year deferred yesterday out of the 263rd for, I think it's a impeding breath case. So he's back on probation out of felony, but he's here with us. So he is, so you know, they didn't attach any special conditions like why I'm acting. He's 38 years old, so nothing like that. But it did indicate the TRAS, given his substance abuse history. I think everybody kind of had a thought that it was going to include inpatient potentially. I think he was prepared for that possibility, but
Yeah, they didn't.
he hasn't done it yet. So
I was gonna just unset term. I mean, why?
given that he's on probation.
Right, there's, why double them up? Why create life more difficult as it, and he hasn't done anything as it is, so we'll just unset term, just, yeah.
Right, that's what I
Yeah.
hear. Okay,
Okay,
thank you.
for sure.
You can walk with them, knowledge.
Do better, it's a little harder to hire.
So to have the interpreter.
Yeah, let's do it.
All right, bottom of 10, Morales. Come on up.
Victoria. Dick. How many more are there?
There's like 3 attorneys that are not here.
Okay, good morning, Mr. Morales. Sir, good morning. Sir, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On January 27th, 2026, the officer met with complainant witnesses, defendant's brother, who stated he was driving the defendant while running errands when defendant requested to drive. Once defendant started driving, he operated the vehicle erratically. When they got home, complainant witness started to enter the residence when defendant struck him with a closed fist in the center of his chest, causing pain. Inside the residence, defendant attempted to lunge at him in an aggressive manner, but witness's father intervened. Witness stated he saw defendant strike complainant witness in the chest and lunge at him. Sorry. Defendant also told witness, when you go to sleep, I will hit your son.
Do we know if alcohol or any kind of drugs illegal drugs played a part in this? And what time of day or night was this, do it say?
It says 21.7 hours, so
That's-
military time.
Yeah, okay.
Um,
Any kind of indication of alcohol?
I don't see a mention of alcohol or any drugs. And then, oh, 1 second.
Your Honor, the defendant stated that he knows his father, to be concerned about defendant's past drug use,
Right. Mhm.
and that's from the dams, Your Honor.
Ms. Morales, I'm gonna find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using weekly. If I find that you do, I'm gonna put you in jail and I'm gonna make your bond high. Do you understand me? You
Yes.
will not get any more PR bonds. This is not a revolving door. And now within 2 years, you're working number 4. What do we need to do to get your attention? Because apparently we haven't yet. You are not to have any contact with the complaining witness in this case, not to go where they live or work. I'm entering now a magistrate order for emergency protection that identifies Mr. Morales as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. You cannot be in possession of a firearm. You cannot threaten, harass, use a third party to communicate a threat or harassing behavior to this person. You cannot go within 200 feet of the Broccoli Lane house as well. You violate this, they can file additional charges against you, and a violation of a protective order is the capital murder of misdemeanors. Do you understand?
Yes.
We are going to reset your case to give you time to hire a lawyer. I'm going to have you go to Victoria Center reset, and then I'm going to have you take your seat in the jury box. Expect a test soon. If you fail to appear, then a warrant issues. Do you understand me? When I mean no contact, I mean no contact at all. If I find that you go back to this house, if I find that you have contact, it's going to go sideways for you extremely quick. Hey, Roxana, on Martinez, right here, this gentleman, it's on page. Bottom of page 10, test in a week, please. No drugs, no alcohol, no weapons, no contact. That, but I want to test it in a week and then not to go back to the house. It's bottom of page 10, Morales. Hey, Manny, you ready?
Yes, sir.
Come on.
That'd be great.
You have an arraignment?
Oh, do you want me to come back after running?
No, we're done.
It's that hand.
Okay.
So came back today, the state is gonna keep all space. I'm not, I think it's been a lot of shuffling with the chief recently, so. We're okay if the state wants to, we'll go back to time to keep all the space.
Well, let me see how old it is first.
I think it just hit 6 months today.
Is he in jail?
Next one, you know. I'll say, give him like a week.
Who's the DA on? No, he's the DA.
Sean.
Oh, what's up with Sean? Is Sean not here today? Okay, so
We'll come back.
can you, on Canon, can you put an eval on it to get it done?
Yeah, Judge.
At one day next week, I don't care. You pick it,
Maybe Tuesday.
please.
I have a piece of you.
Yeah. it's,
Yes, from probation.
No.
Stephen Eric.
There, if you can move it. What is it?
254
Okay,
3469.
That.
10,001. Thank you.
Yeah.
Good question. So, would you be close to waiving Mr. Cannon?
Yeah.
Okay.
Yeah.
You're opposed or not opposed?
No, I'm not opposed.
Okay.
Yeah. Hey, good morning. How are you? With who? Hey, Victoria. Who?
Who wants to review it first?
On which? One?
Oh, top of 14.
Oh, yeah, it's 300 days. So I'm gonna give you a regular setting, but then after that, we gotta figure out what we're gonna do. So, and it's failure ID. So we'll give you 30 days, but he's gotta be back. And then we gotta figure out what we're gonna do. That's it.
Okay.
After that, I don't care. No, it's a failure ID. It's just, no. Just let him know if he fails to appear again. Yeah.
Okay.
Yeah, you take it.
So. That makes sense.
All right, how's April coming home in the first? Make sure you're talking to text messages. Make sure you get it. Also, we want to. Just as this day,
Hey, so should I not sign this?
Council, will reset.
Yeah, should I not sign it? So you're not gonna process it when they approach?
Yeah, it's up to you. I want to say it. I'm gonna read it.
Judge, can I just get what the bar conditions were, like for, Adamic? Is an FSPI?
Yes, no contact with the complaining witness. This is the one where it's kind of like a road rage. So no reckless driving, no road rage, no contact with the complaining witness, no weapons, no driving without a license or insurance. I don't know, is there anything else you can think of?
No, I think that's done.
You thinking? Okay.
Thank you,
That's
Judge.
it, yeah.
Okay, now is. 24 to the 26th. Tuesday.
Yeah.
I was gonna say, no. If the mitigation packet's not submitted on that day, then we're following.
You're gonna wait for Ariel or somebody to go to the church? On the jurisdiction? Are you gonna wait for somebody to approach on the jurisdiction? Okay. So it's not a cost. I wanted to bring up something. Do I?
The police and stuff?
Yes.
Okay.
And before we were doing probation, so just predicted things we have approached. Right, it's true, and we were just and we would hit the DW nothing, and then you have to pay that. Or pay that with your fine. And then before, and then sometimes we waive it, depending on the just go first, and then, yeah, we'll waive it. But now we started doing
Conditional.
the conditional one where,
Well, I want you to still do it, order it, put it on,
okay,
and then I can wait it later.
so if that's the case, then it'll still look different. In the sense where whatever amount we have in the ordinance, because it's gonna be a footage clause, whatever amount that is, it has to match like the pay rate for the amount of months they have for probation, so. Or you're doing like, it's 1 year, or 12-month probation, she'll have to do a 10-month payment plan of $3,000, and they'll have to pay $300. And then if they can't pay that, then she comes to you and lets you know, and like, well, if he's doing everything else, we'll extend it.
Yeah, they can always get an extension.
So,
They can always.
yeah, just making sure.
Yeah.
I know she's busy.
No,
She
they
can answer.
can always give an extension anyway.
So,
They can always go to where the payment window is and ask for an extension if they need it.
well, it wouldn't be the collections here, it would be through probation, it
Okay.
would be all probation. And
Then
it
they
makes
can always
years.
ask the probation officer for an extension, you know?
So I'm thinking is. The conditional ones, it's just treat it as. So 3,000, it's 12 months, so 300 a month. We could wait a later, I don't know how that would look on your end.
Because I would tell her, yeah, waive the fees or no, you know, or we'll issue a case.
Oh, when I was the fees, it's not like those are made conditions.
Okay.
No, I mean. If you think you need to, I don't, if you end up doing it and just signs it, I'll always just change the full straight like the word. Our collections downstairs, they're not.
I would watch out more for it just depends on how it's on the site. Or including.
Mhm.
So.
Taylor's on Zoom for the range we have. Stand up.
I don't see anyone.
Okay.
Hey, just the last name, please.
For what?
Okay, jail or Avant?
His jail, Ariel filed some.
Oh, okay. Is this what you were talking about, guys? On white?
This will got filed for that.
Okay,
Oh, okay.
Yeah, he's still frozen for.
got it. All right, I'll send it now.
Okay.
Okay.
Did you want to revisit top of 11?
No, not yet. Not ready.
Because he didn't send me that. Because the attorney for bottom 12 said she was saying.
Well, scattered.
For the bottom of 12, are they, they're opposed or unopposed?
No, that's totally fine. I didn't know that it should be subject to it, so I don't think that you know. It's better. So, but I understood, she drew. Hey, Donald. You're saying ball condition? One more. I sent an email.
Yeah.
We're going through something, right? So there's a for this one. Specifically, because of the case. Luego con su 49 cents central, it's the primarily from the portal, the local documentation. Special education.
Hey, Mr. Gans, how are you? Do you have an arraignment with us today?
I do not, I have an off bucket. We did, week ago, or 2 weeks ago,
Okay.
we did a 90-day license suspension with credit for ALR.
Oh, did you get the date?
If we did it, but it didn't end up on a judgment, and DPS suspended it for an additional 90, so I filed another protest.
Do you want to let him know?
Okay.
Did you know about that?
Oh, I was talking about it. So the DPS correction report was sent the day to my supervisors, but since DPS is still behind receiving conviction recordings from our CJIS group, like shifts
Bottom of 16.
in order to get.
There's no council
DPS
attached.
recognized that they can they want us to send them a new report that that the commission happened. And that's why I filed it back.
I don't know.
Yes. I saw it. That's what I.
So we have that signed.
Is the defendant here?
You know,
Well, Ella created my talking to about it.
Victoria is the defendant here. Who's in the box?
I got to do it. I put the DPS warrants on air. It's just having the posted. That's the only problem.
Hey, you're taking, okay, Taylor.
Good morning, Judge.
Hey, just give me the last name of your client, please.
Martinez.
I would still do it. Usually the entries on jail before that AL is just AL and send something right here. Policy. So I see where we'll send the. But I make sure that.
Come up, Mr. Martinez. Can I borrow you for a second, please?
so we don't mess with it.
This is Mr. Martinez, possession of a dangerous drug.
Thank you, Your Honor. What do you think?
Take care. Please tell me discovery is complete.
I'm waiting on the lab.
Lab is the only thing that's in progress, so.
I mean, how long is it gonna take? This is 256 days old.
So, yeah, on June.
Hmm?
June 30th is when they requested
Of what year?
Oh, no.
2025.
You still don't have it?
But I was like, I don't know. I thought I figured.
Clear the labs.
I'm sure that he absconded quite a while and due to the fact that he absconded, it puts the case in a holding pattern. Is that right?
Yes, Judge. I'm taking a look at discovery in the lab. Sullivan? Just 1 second, Judge.
I'm now testing you 2 times a week. The next time you fail to appear, I'm going to quintuple your bond. Do you understand me? Did they give him a PR bond? And Mr. Martinez?
Judge, usually the log gets sent to us. But I'm not seeing it in the system right now. I can try to follow up with the officer to see if they have an update on it.
Yeah, it's probably a good idea. It's 256 days old and I'm ready to put this baby to bed. So you can, please.
I'll reach out to the officer.
So I'll set you off like a week. You know, try what you can to get either the labs or find out what's going on.
30 bomb, maybe district.
Okay, Mr. Martinez, the next time you fail to appear, you have already violated bond conditions 2 times. The next time I'm going to go bananas on your bond. Do you understand me? I'm gonna have you sign a reset. We will see you here in a week and then we move forward on your case.
Yes, sir.
Come on. So we're in Monday, Thursday. Yeah.
Pre-trial bond conditions?
Yes.
True.
Taylor, I'm gonna give them a little bit of time to try to get the labs back, but I'm not gonna wait forever, you know? We move forward whether they have it or whether they don't. Okay?
All right,
I'm gonna
Judge.
set you off a week, but I'm gonna test him more so.
Okay, I can't do it next Friday, so if we can do it either Thursday or. the
Whatever you
following
want, I don't
Monday.
care. Just whatever you want.
Okay.
You wanna do Thursday?
Either Thursday or the following Monday on the 3rd.
I don't care. Thursday or the following Monday?
Monday the 16th?
Sure.
Yeah, that works.
Okay.
Thank
All
you,
right, we
Judge.
got you.
All right. Hey,
One more question. There's a non-disclosure. Are you opposed or unopposed? Poindexter, please. Oh, really? Okay. Hmm? Oh, you did email? Got it.
Judge, bottom of 16, did you want me to appoint on that one?
Roxana, did Mr. Umana get the device like he was supposed to?
Adami?
Come up, Mr. Umana. Etch. You were ordered to get a device. He has a portable device.
I don't have a car.
Okay, all right, I'm cool with it as long as he's got the portable. All right.
But I feel like.
They didn't, no one said in the thing that he got a portable device.
I need help with the water.
I need help with hair.
Sorry,
What do you do for a living?
I just got a job. Today's my first day, but we're gonna have a break off, and then I'm not gonna pay us and whatever you're making.
What are you doing for a living?
Work for dicing,
Okay, and how much money are you making a month?
like 1,500. But I need that to pay the rent.
Edge, can you give him an application, please? I need to know everything about you, how many cars you have, whether you have any cars, how much money you have at the bank, whether you're married, whether you have kids, and then I'll take a look. If you put zeros, I'm going to send it right back to you. You understand? Please. I don't know, because I'm gonna talk to the lawyer if he gets one, because, I mean, it still picks up a DWI.
Yeah, and he has a scrap from his felony.
Oh, he has a felony too?
Do you want me to hold to about information from, on that, stuff?
Yeah, and they're just gonna tell me whether they're opposed or unopposed. Yeah,
Okay.
And the direct email to Bernadette was longer train.
Ms. Swisher. So I just got an email from Bernadette that says, I don't believe she's eligible based on her previous convictions. But I don't know if that's right.
Okay, what I saw, I thought she would be eligible. She completed the community supervision. And I have the order of discharge from community supervision, from education. I don't know why she wouldn't be eligible. She was able to get an expiring on, so one of the items, in her criminal history, she has no felonies.
Well, what happened on the felony assault?
I'm sorry.
No, that was reduced. She didn't specify why, but
How late are you gonna be here? Can I go to another court and then I come back and?
I'm inclined to grant it regardless,
Oh,
you know? I mean, I don't know why a previous conviction would bar.
right, I just don't see.
Do you have any idea?
I mean, I would need to talk to Logan about it. I think Logan indicated that she'd have to wait 2 years. I would have to talk to Logan and confirm.
Do you want to run out real quick and see?
What I did, I would take a look at it.
Because Your Honor, she started the deferred adjudication on June 7th.
I don't, but I don't, what chapter offense? Under, you know?
Sorry.
I can just hear you.
Yeah.
So the FSGI, it's in the transportation code, so it's not in chapter 20, 21, 22, 25, or that would require a 2-year waiting period, you know? Yeah, I guess talk to Farwa, but I'm gonna grant it, pending they say something crazy that why I would need to not grant it, but yeah, I'm inclined to. So I don't know, unless you can justify why we should.
Thank you, I'm Abby.
Of course, yeah.
My client is here too, so make sure he was.
Yeah, she didn't have to come there. It's okay.
Oh, that's fine.
Oh, we're talking about-
Okay, all right.
for future reference, it's not necessary.
Thank you, Your Honor.
Of course. Thank you, Ms. Swisher. Jamie.
He just left.
I'm waiting to see if she can justify why she say no. But yeah, just the last name, please. Who we got?
Michael Black.
Okay, tell me about Mr. Black.
Your Honor, the defense is seeking a bond and the state has position of no bond. The out-of-state warrant is coming out of North Carolina for discharge of a firearm and assault with a deadly weapon with the intent to kill. There has been an extensive criminal history that dates before 2019, but since 2019,
Well, hold on, let's bring him out so he can hear this. I mean, do you mind, Edge? Give me 2 minutes so we can, because he needs to hear all this too. You want to talk real quick while we're waiting? Speed?
You don't have to have a little. It's gonna take a minute.
Okay.
Martinez, does we have an arrangement ready? And you want to wait on?
Yeah, just.
Okay. Hey, I'm right there. You're gonna bring your phone conditions?
Good morning, Mr. Black.
Good morning.
Your lawyer is asking for me to set you a bond. I don't know. I've never met you before. I have to get to know you in a very short period of time. Two things concern me. Number one, if we set you a bond, are you going to go back? Number two, are you a danger to our community? If we do give you a bond, are you going to leave a wake of destruction on your way back if you go back?
Oh, sorry, so I can't go here.
Hold on. Everybody says no. Everybody says no. What we detail and what we find is paper really tells us who you are. Criminal history, do you have any open cases, length of criminal history, when the last, if you have any criminal history, when it was the last, how recent was it? All this gives us cause to see whether you are a danger to the community and whether you're going to go back or not. If there's just way too much drama, you know what I mean? So all this plays into it. I know what you're going to tell me, that it's little bunnies jumping in the woods. Everybody says that, but paper really tells me who you are.
So, yes, Your Honor, this is for an out-of-state warrant coming out of North Carolina. Discharge of a firearm and assault with a deadly weapon, with the intent to kill. In addition, as it relates to the criminal history, The defendant has picked up charges, several charges per year since the year 2019, with a charge dating before 2019. Out of North Carolina, fleeing and eluding South Carolina, uncontrolled substance, North Carolina, DWI, California, possession of controlled substance, DUI, North Carolina, driving while intoxicated.
Dang, is that 3 so far? Or
That's
DWI?
about 4. We're out of 2019 and 2022, and we still have more in 2023, 2024, and 2025.
Keep going. I'd like to know. How many more do you got?
2023, North Carolina trespass, 2023, Florida trespass, theft, and burglary. And with those offenses picked up in Florida, there was a failure to appear for those charges.
So he's got charges in Florida, South Carolina, North Carolina.
Indiana, there are 6 states.
Hell no, man. No, you're playing hopscotch with the states, man. No. Not gonna happen. It's way too much drama. I'm sorry. Yeah. I'm sorry. Just too much. And now you got these cases. I'm sorry, Mr. Weeks. It's just way too much.
Thank you.
Has he waived yet or no?
He has waived.
Okay, so, if they don't come pick you up within the 14 days of the day that you sign the waiver, Harris County is going to release you. However, understand that that warrant will always remain active until you go back to North Carolina and take care of it. Do you understand? Okay, good luck.
Now, the 14 days is that,
From the day you waived, when did he waive?
March 4th.
So that's 2 days ago. So you get around,
I sound unfair, but with that also being said, is business days or is it just regular days?
it's every day. Or is it, I think it's business
It's
days,
each day counts.
each day, yeah.
So today I should be expecting with 14 days.
I don't know, I'll let you guys calculate it, man. Okay,
Thank you, Your Honor.
Thank you.
thanks, guys. Ready?
Yes, sir.
Just the last name. Who do you got?
I got Miss Stone.
Oh.
Miss Stone.
What do we do with Miss?
Well, Your Honor, I think she would like to explain some things. We have some issues with the testing. She's supposed to test twice a week. So they're having car problems, financial problems. And I don't know if she's supposed to pay each time she goes and tests.
No, she don't pay anything. We waive everything. Always for every person. I waive all the money for
Can I
everyone.
bring her up?
Sure.
Do you mind? Come on. I think we can work it out, Judge. She has been very communicative with her attorney. She's staying in contact with me.
So it's been roughly around 40 days. You failed to appear for the last drug test.
He was presumptive positive for Jason.
All right, so I'm gonna give, just to be on the, give caution, I'm gonna give you another 2 weeks to clear out. But at that point, if you're not clear, you understand? Okay, all right.
Thank you. Maybe we excuse me.
But at 2 weeks, Mr. Beeden,
That's it. 2 weeks. You gotta drink water.
All right.
You gotta exercise. You gotta do cardio. You gotta sweat it out, you know?
okay. Mr. Hamilton, come on up. Good morning, Ms. Thomas. Happy Friday. It's finally for a man, finally. Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On February 27, 2026, approximately at 1:52 a.m., an officer in Harris County, Texas, observed a motor vehicle traveling without lights at night. There was a search conducted. The defendant driver advised he was coming from a company party and had a few drinks. For the SFST, it was a 6 out of 6, 2 out of 8, and a 3 out of 4. Driver's license is eligible.
They like pull them over and they just start searching?
A traffic stop was conducted.
Is this the thought police now? Driving while black or what?
He's traveling without lights at night.
Great. That doesn't mean you're intoxicated. That's it?
He had a strong odor of an alcoholic beverage, emitting from his breath, and had glossy eyes, slurred speech.
Okay. That's more. So then they get them out. Do they do field sobriety too?
Yes.
What were they?
6 out of 6 HGN, Your Honor, 2 out of 8 walk and turn, and 3 out of 4 one leg stand.
Any priority to be honest?
No priors, Your Honor, and his driver's license is eligible.
So do they take him back? Do they do any breath tests, blood tests?
The GIC was read and he refused to provide a sample, Your Honor.
Yeah. So do they take blood or no?
Yes, Your Honor.
Yeah, okay. Mr. Hamilton, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. You are not allowed to drive unless you have a valid license. You must also maintain liability insurance. That is also a condition. If you don't have car insurance, then do not drive. You understand? Because you have a lawyer, I will waive your appearance, but you must stay in touch with her and she'll tell you if and when you have to come back to court. If she tells you she cannot get a hold of you because you're playing games, I will revoke your bond. Just stay in contact with her. All right. For now, we'll have you sign a reset. You'll get with Roxanne for conditions and then you're free to go.
Thank you, Judge.
Please. Yes, ma'am. Thanks. Ready?
Hey, Judge. Approaching on Gonzalez.
Okay. Sign this real quick. You said in the jury box?
In the jail box.
Ah, okay. Weird. They didn't give a PR box?
No,
Why?
I'm not sure.
Let's read it. So the magistrates always have to justify
Yeah.
why they do. Let's
Yeah.
read what? Let's read it. So it says here, I find by clear and convincing evidence that there are no non-financial conditions of bond and reasonable alternatives to pretrial detention that will suffice to reasonably assure the safety of the victim. So 2/27/26, complaining witness stated during a verbal argument, defendant pushed complaining witness. Complaining witness fell, bruising back. 3/4/26, defendant took complaining witness's phone as complaining witness was calling law enforcement and slammed phone to ground. Defendant stated, if I go to jail, I'm going to kill you. I'm going to shoot you.
So he's indicated to me that he's already paid the bond. I think it's just hasn't posted yet.
This is Gonzalez.
So I indicated his brother had actually paid the bond yesterday, but it hadn't posted yet. I haven't spoken.
Well, I think that there are other alternatives that we can do to kind of protect the complaining witness to ensure that he doesn't go near her. And in the event that he still takes matters into his own hands, at that point, we'll put him in and make it a really high bond, and I'll bring him out and I'll tell him, I firmly believe everybody deserves a chance. Do you see any criminal history on Mr. Gonzalez?
I'm running the CIC right now, Your Honor, but it does not look like it.
That's nuts. Hey, can I have Mr. Gonzalez, please? Do you need a translator?
So you said that his brother had actually paid the bond yesterday, but I didn't see that any bond was posted. Nothing yet.
Do you want me to wait or do you want a PR one?
Well, so I guess the question would be, if he has paid bond, would you be willing to waive the GPS monitor?
Hell no. That's what, I mean, I was gonna give him a PR bomb, but I'm gonna put the monitor so I know he doesn't go anywhere near. Because that's the only way I can really ensure that I'm not gonna take word for it.
I'm sorry.
But
If we can do the PR bond.
I'm happy to give you a PR bond. I just want to inform him that if he starts just doing things he shouldn't, then.
I'm sure.
Hey, Mr. Peden, we'll randomly do once a week now,
Once a week.
once a week randomly.
Once a week randomly.
So just have her ready that she can get called, okay? Yeah.
Thank you, Judge. That's
For
what
sure. I figured it was. How's jail?
Sorry?
How's jail? Sucks, right?
Yes, sir.
It's supposed to. It's not supposed to be fun. It's supposed to be there, so when we find that people are dangerous, they're damaging or hurting our community,
With him,
this is what we have at our disposal to ensure that our community is protected. That said, I'm a firm believer that everybody deserves a chance. You have not been given a chance. I'm willing to give you a chance, but you're not to have any contact with this person whatsoever. Do you understand? I'm entering now a protective order that limits you or bars you from having any contact, going within 200 feet of where she lives or where she works. And I'm going to put a monitor on your ankle so I know where you are. If I find that you go near her, where she lives, where she works, if you attempt to have contact with her, then we will have issues. I'm going to give you a PR bond today, but this is not a revolving door. I'm not going to give you a PR bond after PR bond. You have one. If you violate, then I'm going to put you back in jail. I will revoke the PR bond and I'm going to make your bond high. Do you understand? I don't know who you have in your life, but if I make your bond $20,000 to $30,000 and you don't have anyone to pony up that money, do you understand? When I mean no contact, I don't care who initiates the contact. If she calls you, do not talk to her. If she texts you, do not reply. If she comes to your house, don't answer the door. You're the one that's going to go to jail if you have contact with her, and I don't care if she initiates. No contact means no contact. Do you understand? As also as a condition of your bond, you are not to be in possession of any weapons whatsoever. If you have a weapon, likewise, you're involved. You violate this, they will file they can file additional charges against you. And a violation of a protective order is one of the worst misdemeanor cases you can pick up. Do you understand? The only other thing I'm going to advise you now is that you must stay in contact with counsel. If he tells me he cannot get hold of you because you're ducking and dodging, likewise, a warrant will issue. You understand?
Yes.
I'm not asking much from you. I just want my community safe. And if you can adhere, then you and I will be best friends. Understand? Okay. So we'll grant him a PR bond now. He'll get a monitor prior to release. And then after that, he'll be with you. Okay. Give me a sign. Ms. Donaldson.
Really quick, Judge, there should be a motion here if you want, it's a standard.
Okay, I'll sign it.
Thank you.
Yes, ma'am. Hey,
May I approach one?
just the last, yeah, but just the last name. Oh, is it off docket?
yeah,
Okay, what's your cause name?
I just added it disappears. I guess I'll come back.
I'm not Trevino.
Yeah. Yeah. Yeah.
Hey, did you find a reason why I should deny?
Yes, Judge.
Why?
So she needs to wait for the time period of termination of the deferred
Why?
or non-disclosure. I have the on her.
What chapter is FSGI that would cause for the wait? It's a transportation code. It's from chapter 550 of the transportation code. So it's not listed on chapter 24, 21, 42, to where it would initiate a waiting period. That's what I saw.
I got it.
Give it to me.
Pop back up.
That's okay. What is it?
25,849,87. Like you.
Okay.
I like your scope, by the way.
Thanks, man. Tell me about Mr. Trevino.
Okay, so Mr. Green, we came earlier this week. He's a veteran, he's a disabled veteran, and he's trying to get more benefits. He's got a scram device on his ankle right now. He's gonna have some X-rays done on March 11th.
Oh, we spoke about this already.
Right, and so he has a interlock device in his vehicle, and he's blowing 2 times a day, every day. At every, a negative every time. So one of the things that you guys talked about is having get a portable device and having to blow that day. Well, I thought that was kind of really not necessary, because he's already blowing 2 times in his machine, and now PTO, and basically he's saying that it's going to be difficult to have the machine put on that day, take it off the next day. That's what we're asking to do. Or they're asking.
If we give them the portable, it's gonna take about 2 days when you see they get it. So I mean, that's the minimum. I don't know if they're gonna have any portable ready.
Why?
Today. That's just how the vendor works. They need to have sooner. If you get that clarification.
Yeah, then we'll get it sooner. I mean, he's got it on the 11th, so we could schedule it now, or he could pick it up the day before or the day up. I mean, if we schedule it, if it takes 2 days to get, then schedule it beforehand.
But Judge, the fact that he's already blowing into device every day.
I'll take off the one in the car. I mean, if he's got a scram, he's got a portable, then I'll take off the one in the car.
But do you think it's hard?
I'd rather him have it on him at all times than just on the car.
Okay,
So I know that he's not using it at all.
okay, so we can then.
With his history, and I'm not taking any more. I don't want to take any chance.
I guess I have to speak to you about maybe the better court judge. He's served.
Well, I mean, if you're gonna do that, you need to like now, because it takes a long time.
We just got all the discovery lot. Yes, 2 days. We've been waiting.
Then you need to tell me if it's
Yeah.
taking this long to get discovered, because I will put pressure on them. But we're now at 190 days old, and you're not telling me veterans court. That's gonna take another 6 months to get into veterans court. Because they gotta do a TRAP and they gotta do the orientation. It literally takes another 6 months. So for future reference, if you see that's taking a long time, a lot of people come to me and say, okay, look, Judge, it's now been 140 days, we don't have anything. Then I'm gonna give them a 10-day discovery hearing. If they don't have it, then it doesn't come in.
Okay. Should have done it.
Yeah, but I mean, everyone is waiting, 200 days an hour when it start doing all this. Well, then now it takes another 6 months to get everything done.
Okay.
That's why every case now we have is 250 days plus. So I want him to have a device at all times.
Okay, so.
I'm willing to take the thing off on the car as long as I know that he's got a device on him at all times, because my main concern is him using at any time. That's what I don't want. So I mean, I'm not gonna trust him on that one day that he's not gonna use. He's gotta have a device at all times. So
Will you still let it drive? Because it's driving.
yeah, because as long as he has an operational device, but if one of those devices goes dead, then I'm putting his ass in jail.
Yeah.
But he's gotta have a device at all times, so I know that he's not using it.
Okay.
That's my main concern. I don't want him to use with an FSRA, a DWI, now another DWI, and all within a matter of 2 years. No, I don't want him drinking at all.
That is it. Thanks.
Okay.
Judge, I'm gonna check with Logan again on that non-disclosure.
Did you get an email from Mr. Sims regarding Lizardi? There should be it's from Mr. Sims. No, sorry, Arthur Sims. Yeah, different Sims. I'm gonna have you, Arthur.
Yes, sir.
I'm gonna have you send it to someone else if you don't mind. Let me get you the email real quick. You got it? Yeah, he's here. He's here. Is it on, Arthur, is it on docket today?
Yes, sir. It's Lizardi.
Oh,
You see it?
yeah, and she got a different email. Can you resend it to me?
Okay, I'm gonna send I'm gonna
Sure.
send you a different email to send everything, okay?
I will send it as soon as I get it, Judge.
All right, give me 1 second. Let me get the.
Yes, sir.
That's it.
Got it, Judge. I will send it right now.
All right.
Thank you, Judge.
As soon as you send it, she'll get it and then we'll take care of it for you.
Thank you, Judge.
Okay, you wanna go to the list?
Will we get an acknowledgement?
Yes, but pending them getting all the documents first.
Judge, on the bottom of page 1, did council ever approach on that one? 'Cause he was here. Joe,
Say it again?
bottom of page 1, did council approach on that arraignment?
No, so let's just do it.
Okay.
It's 11:15. Calvo, come up. All right, good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On February 28, 2026, an officer in Harris County, Texas, observed a motor vehicle going 92 miles per hour at 2:35 a.m. on Katy Freeway. There was a search conducted. The officer observed scent of alcohol, beverage on the breath. strong odor of alcohol swaying. Defendant admitted to drinking 3 beers. On the STs, there was a 6 out of 6, 4 out of 8. And a 3 out of 4 on the one leg stand.
And Your Honor, the signs of alcohol were the strong odor of alcoholic beverage, slurred speech,
Yeah.
bloodshot, glossy red eyes.
Okay.
And admission to drinking, Your Honor.
Blood test, breath test, do they take?
DIC was read and provided a breath sample, but all were unacceptable. But a blood was consented to and blood was drawn, Your Honor.
Got it. Any prior DBIs?
No priors, Your Honor.
License?
Eligible.
Got it. All right, Mr. Calvo, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you are ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds. Do you understand? Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. I don't know why they're here. They're not here by now. Hopefully they'll come a little bit later. If not, we'll have Victoria reach out to them to get a date. We will waive your appearance to stay in touch with them, and they'll tell you when the reset dates will occur. Like I said, you're going to be randomly called to go take tests. If you don't appear for it, or want issues. Do you understand? Okay, come on, and we'll have you sign all the documents.
It used to be. Daniel Wilson, not sure.
Yeah, just made my last one.
Hey,
Wilson,
top of 4?
Spanish speaker. I haven't seen the country.
Is the defendant here?
Yes, Judge.
Let's just do it. I mean, really, we're basically done. I mean, and then I'm gonna talk to.
Thank you for being that. I get it.
Barbara, hey, Mari, for a second. So on Mr. Norrell, he was doing 80 and a 20. Is that right? Norrell,
Oh, it's not yet.
it's a reckless.
So it was in the 60, it was something that was the speed limit, it was a construction.
I feel checking again, Your Honor.
Yeah, because normally a construction zone is like,
Yeah, I believe 1698. And then this
is 60 the normal speed limit?
I believe 60 is the normal speed limit. I can check it out, but it does state in the that he drove through the construction. But within the states that the posted speed limit is 60 miles per hour.
Where did, it doesn't say 20 in there anywhere, doesn't
It
it?
is.
Come up, Mr. Norrell. I was about to take your privilege to drive away from you had it been that you're driving 80 and a 20, because that's just. If I find that you drive recklessly again, though, I will put you in jail and I will take your ability to drive away from you. You understand?
Yes, sir.
There are proper ways to drive. There are not proper ways. We have enough death and destruction on our streets. We don't want any more. Do you understand?
Yes, sir.
We're going to reset your case to give you time to hire a lawyer. I'm going to have bond conditions created for you to sign. Once you do that, at that point, you'll be free to go, sir.
Thank
So hold on. We'll have you sign a recent one. So the usual for reckless driving.
Yes, Judge.
Did you get the email from Sim?
Yes, I did. And I'm gonna file dismissal.
Okay. Mr. Sims, they're gonna dismiss your case.
Thank you, Judge. Y'all have a good weekend.
You too, buddy. Take care.
Yes, sir. You too.
Okay, are you ready?
Yes, Judge, I thought this one, you asking me, Judge?
Got it. Mr. Mendez, okay.
He's still about signed.
Good morning, Judge.
Hey, talk to me real quick.
Yes, I have Ms. O'Hara.
Just last name.
O'Hara.
Okay. Actually, let me do this. All right, good morning, Mr. Mendez. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 30 days in jail with credit for the 10 that you have done. You need to understand that this charge will go on your record. It will be there forever. Because this is now a conviction, if you ever pick up another evading arrest, the next one will be a felony offense and you're looking at years instead of days. Do you understand? You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up your right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do? You want to plead guilty to this offense? Are you guilty of this offense? Okay. I'm going to find you guilty, sentence you to this agreement. Does this case take care of the
Yes,
felony?
Judge, pursuant to this agreement, they're gonna dismiss the felony, but the prosecutors here aren't comfortable doing that, so they're notifying the felony prosecutor.
Okay, yeah, right. Here's the other thing. Your bond is 2501. It would only cost you all of probably $200 to get out on bond. These are things you need to recognize when you're out there in the free world and there are shenanigans afoot. No one's willing to even pony up $200 to get you out of jail. So the next time you're out there, consider this. Do you understand? Good luck.
Thank you, Judge.
Hamilton?
Okay, O'Hara.
Yes.
And Calvo?
Where do you want to go?
Yes, Judge, we're sending these cases for trial, both of them. And I believe this hearing was just to admonish Ms. O'Hara.
Okay. Is she here?
Yes, Your Honor.
Okay, come up, ma'am. You've made offers?
Yes, Judge, we made offers.
Okay. What offers have you made?
Time served and dismiss the other, time served on the ABI, or I believe it was. Yes, time served on the ABI, dismiss the
All right, ma'am, good morning. Understand that you are charged with 2 offenses. You want to set them for trial, okay? But once you set it, we are going to go to trial. I'm not going to take any more offers, not trying to plead guilty on the day of when we have a jury coming in. So I'm happy to set these cases for trial for you, but if we set it, we're going to go and there's no more bargains after that point. Do you understand? You don't have to make a decision now. I'd like to talk to your lawyer, but we're going to trial on 2 cases. First, you're going to try the assault. Right after that, we're going to try the other case and on the. So you're going to trial on both cases, one right after the other. Do you understand?
Yes, sir.
All right, I'll let you guys talk. Let me know what you want to do. If you want to set it, then just 30 days from today, you'll be going to trial. Okay,
Okay, Judge.
okay.
Let me go talk to her, Judge. I did want to just point out that on Failure to ID, there are some videos that we've been requesting from the state from the reason she got detained, and it seems, I'm not sure if they're available or not, but they haven't been.
Farwan, that's a problem.
Yeah, I'm taking a look at that right now. Thank you, Judge. I'll be right.
Sure. I mean, we're at 170 days. If you don't have videos, then I'm going to give you a 10-day discovery hearing.
Take a look at that.
Please.
It was a separate case, I was involved with this case.
I don't know, just, are they, so they're not at the same transaction?
I need to look into it to confirm, Your Honor. It's based on our notes. It looks like they might be a separate transaction. But I need to take a look. to confirm.
Oh, yeah, they are. Mhm.
Judge, are you ready for the Spanish arraignment?
Yes, let's do
All
it.
right, top of page 4, Gomez.
Regardless, they're both old. I'm ready to set them both anyways, so. But you need to see if there's videos. Regardless, I'm gonna give you, if you don't have it, 10 days.
And I'll take a look at that.
Okay.
While we're waiting on the I'll see you outside. 5 and 6. Davidson,
Yeah, it's,
the one on page 6.
again and again and again and again, 5,002 on both. No show? Okay, who is that? What was the last name? Okay, so 2501.
Oh, hold on, Ray. I'm sorry. There is
What?
there was an off-pocket reset to move the case to the 16th.
No, you can't just who did that?
Okay, the council said they were out of time or something. Was that this
But
morning?
we have to know first. You can't just.
That's probably why, the defendant did check in. He just left, I guess. Yeah. No, it's- It's still probably should be something. Yeah. When we published it with that. Why is he still on my docket?
He has 3 and I'm sitting. That's weird.
I thought it was weird too when I did it, I was like, that's today.
What is it called?
So that's why I'm like, I didn't even think I was looking. It's each other.
His bond was but the reset was for Mondays.
Are there multiple, X, Y, 8, 7? Yeah.
Yeah, there was 2 resetting for today and Monday, and we reset the Monday date to,
So then you have to delete one.
yeah. we
Send
have to
it
do
per
that
day,
this morning.
otherwise it'll be, it's on the 16th. I'll delete one.
Oh, no, we have to own it, no, you told me to stop.
No, we gotta delete it, you gotta figure it out. On LPY.
Well, the recent paperwork that published has 39 on the paperwork. So if I delete that, just want to roll it and then delete the other one too. Or you can,
We're on here for today.
It's already on.
It's for today.
it was actually today, but it was,
So those for today.
it was published yesterday, I'm sorry, it was published yesterday and she yesterday. I mean. Okay.
Oh my God, I thought we knew this one. What was this one?
Yeah.
So on the docket, I can write the 16th.
I'll do that.
Yeah.
I'll delete 16 days on the plan. Okay.
I wonder what this means. I know. It was all in the city. Yeah, especially the car. I'm just probably on vacation, someone else is getting. So I know that. Oh, yeah. I think that if I'm able to open the email that. You're not able to open the email.
Yesterday. She must have been thinking something was up, like Yarvon says today's.
It's because they also, they gave him, I guess when they got out of jail, they gave him 2 horrendous settings and paperwork only had today's date. But he did the reset for Monday. So. I mean, he was here today.
But it's gone.
Yeah. So reason it on 16.
No, for Tuesday, because I'm not gonna be here Monday.
No.
Our meeting tomorrow?
You're here on that. You're out on the 9th.
Right, I want to put on the 10th.
Is it okay if you come?
Oh.
We have to do an arraignment. There's no arraignment.
Okay, Martha, never mind, Martha, he's gone.
Yeah, he left. So if you don't mind, SFBF for that Tuesday.
Thank you.
Hey, are we setting it? Okay, so set it. Really? I'm happy to do it. Just set it, but I'm not taking anything else. And then videos or no?
I believe somebody, did you talk to Jesus about it? He's been sitting in, I think he might have requested, he might have talked to the officer or some email, but I'm trying to get more videos.
You've got 10 days. If you don't have it in 10 days, then whatever's not here in 10 days is not coming in.
And to just be transparent, Judge, I've been asking for these videos like since February.
I get, you don't have to justify anything. Don't worry about it. It's right 170 now. Whatever's not in is not in 10 days, isn't it? So for that one, set it 10 days out. Go ahead and set the assault for trial now.
Okay.
And then, once we figure out what happens in 10 days, if everything's in, then great. We'll give you the same trial date as the other one. If it's not in, then that's it.
Okay.
Okay,
All right, thank you so much.
done.
Which one are we setting? We're setting to something. What's the tolerance? Oh, it's on to.
Yeah, talk to Ramona. She'll give you the trial date. Hi, Justin. Let's go through the list.
Page 8, major, declaration of the.
2501.
260. 477.
Oh, page 12, bottom, did you grant that one?
Is that the petition?
Yeah.
Yeah.
Page 13, Lena. Page, oh, just, on the bottom of 16, council. Was it changes? I don't know what that is. Roman. Last year. I don't Because I got that he was, and I guess I don't know.
I think he just stepped out with him.
Oh, did he? I didn't know.
Yeah.
Oh, that's the other thing that's right. Ah, okay. Okay, then never mind.
Yeah, they can't just leave. They got to reset it. I hope they don't just leave. Okay.
All right, so page 17, both cases that were arraignment fellows here.
Okay, and then you want to help Justin real quick? Please.
It's a case that didn't get attached to it on the day when you weren't here.
Okay, just, you know.
Take care. Happy Friday.
Yes.
Yeah, and then Miss Jones. Hey, I think Miss O'Hara wants you.
Yeah. She got it.
Okay, Vic.
Judge,
Nice.
Okay. Wait.
Trade. It was a couple down, but it's gonna find it. We,
The one I think.
yeah, you already picked the reset date, so I just.
Okay, that's fine. Thank you.
Bye, Joe. Happy Friday.
Thank you very much. Thank you. We have some additions coming up.
Got it. Okay, I'm ready. Come up, Mr. Norrell. We'll have you sign it. But hey, just make sure that they can still come back in. Got it. We're done.